One powerful and innovative Cardozo opinion dealt with an emerging area of constitutional law, the First Amendment. That was a subject that Cardozo had also written about in a tribute to celebrate Oliver Wendell Holmes's 90th birthday in 1930, 2 years before he took Holmes's place on the Supreme Court. His approach foreshadowed the debate that would ensue at the end of the decade over the so-called double standard for judicial review of government regulation of the economy on the one hand and government regulation of individual rights on the other. In his tribute to Holmes, Cardozo was already suggesting the desirability of a different approach in First Amendment cases when he wrote, "Only in one field is compromise among pretending absolutes to be excluded or kept within the narrowest limits. There shall be no compromise of the freedom to think one's thoughts and speak them, except at those extreme borders where thought merges into action. There is to be no compromise here, for thought freely communicated, if I may borrow my own words, is the indispensable condition of intelligent experimentation. There is no freedom without choice, and there is no choice without knowledge, or none that is not illusory. Here are goods to be conserved, however great the seeming sacrifice. We may not squander the thought that will be the inheritance of the ages." When he got to the court, Cardozo applied those views and some of the same words in Grosjean versus American Press Company, involving attacks on a First Amendment freedom. The result was the most innovative civil liberties opinion that Cardozo ever wrote. Huey Long, the charismatic political leader of Louisiana, had proposed, and the legislature had adopted, a tax on the advertising receipts of newspapers and other periodicals with a circulation of over 20,000 copies per week. When the constitutional challenge brought by the affected newspapers reached the Supreme Court, Justice Sutherland wrote a draft opinion holding the statute an unconstitutional violation of the Equal Protection Clause because it made taxation turn on the size of a newspaper's circulation. Cardozo had strong views supporting the power of the legislature to adopt reasonable classifications in exercise of its taxing power, and he therefore could not agree with the basis for Sutherland's conclusion. He drafted a concurring opinion that rejected the conclusion that the statute violated the Equal Protection Clause, but asserted, he wrote, that a tax discriminating against newspapers in favor of other forms of business and discriminating against some newspapers in favor of others is an unconstitutional abridgment of the freedom of the press. The newspaper's attorneys had provided an extensive discussion of the history of taxes on newspapers in England and in the colonies before the passage of the First Amendment, and Cardozo recounted that history in his draft. He saw the First Amendment as a response to official efforts to control the press. Here indeed, he said, was a case where a power to tax would be a power to destroy. His reference was to John Marshall's language in McCulloch against Maryland, holding unconstitutional Maryland's tax on banknotes issued by the Bank of the United States. The Louisiana tax was seen as a modern counterpart of that ancient repressive system of taxation. Cardozo referred to the allegation that the circulation standard where taxation began had been chosen in order to punish those newspapers and periodicals that were critical of Huey Long. He concluded, however, that the courts could not conduct a trial of the motivations of the legislature in passing a law. He also used the incapacity of courts in that regard as a warning of the possibilities of favoritisms and tyranny in order to set the stage for a far-reaching defense of freedom of the press. And here is what he had to say in that regard, and I'm reading from his handwritten version of his opinion in Grosjean. He said, "Freedom of expression and the conduct of a newspaper is the very lifeblood of the business, and attacks upon that freedom puts the business in jeopardy. If the press is to enjoy its fitting independence, there must be immunity from taxation except on the footing of equality, either absolute or at least substantial with other occupations. Experimentation there may be in many things of deep concern, but not in setting boundaries to thought. For thought freely communicated is the indispensable condition of intelligent experimentation, the one test of its validity." This is as passionate a statement about civil liberty as Cardozo ever wrote, and here are the thoughts in his own handwriting. "There was no talk of the needs of the state or deference to the legislature. He concluded unambiguously and innovatively that while newspapers could be required to pay their fair share of expenses of the state, it had to be on the basis of equality with other businesses and other newspapers. The statute did not do that. On the contrary, it singled out some newspapers and periodicals for special taxation. The opinion was a splendid combination of history and reason with a sympathetic appreciation of the setting in which the press functions and of modern requirements of its freedom." Cardozo's stirring interpretation of the First Amendment produced an unusual result. Justice Sutherland rewrote his own opinion, placing the unconstitutionality of the statute on the grounds of the freedom of the press, without passing on the equal protection argument. Sutherland's opinion was nowhere near so clear as Cardozo's had been, for it failed to make clear whether it held the statute unconstitutional because of its bad motive, a ground that Cardozo had rejected, or because of the ground Cardozo asserted, the levying of a tax only on some newspapers. Unfortunately for the future of First Amendment doctrine, however, once Justice Sutherland revised his majority opinion, Cardozo decided not to publish his own opinion. Appointment to the Supreme Court ended Cardozo's extrajudicial writing. Unlike many current Supreme Court justices who regularly expound their judicial philosophies in off-the-bench settings, Cardozo immediately felt constrained by the press of business, by the need to conserve his energy, and perhaps also by a sense that the court at that time was already embroiled in sufficient controversy concerning the legality of New Deal legislation. But Cardozo had one further contribution to make to larger issues of judicial decision-making, and he chose what was for him an unusual form, a judicial opinion. The subject was what we would today call originalism, the binding effect of the framer's intent in constitutional interpretation. As we have already noticed, Cardozo had indicated his views in the nature of the judicial process. But it is one thing to express a view off the bench, quite another to do so in an opinion. That was something Cardozo rarely did. His job as judge was to decide cases, not to issue pronouncements on current issues of jurisprudence. But early in his career on the Supreme Court, in the context of a hotly contested major piece of litigation, Cardozo set forth a theory of constitutional interpretation that was breathtaking in its day for the judicial role he expounded. That opinion was his concurring opinion in Homeowners Loan Corporation versus Blaisdell, the Minnesota mortgage moratorium case. Minnesota had enacted a statute permitting courts to extend a mortgagor's period of redemption after default for a maximum of 2 years upon payment to the mortgagee of a reasonable part of the property's income value. Chief Justice Hughes's draft majority opinion upheld the statute against creditor attack under the contract clause, which prohibits states from impairing the obligation of contract. Hughes's original draft opinion relied on a line of cases that had distinguished between statutes that impaired substantive rights, which were unconstitutional, and statutes that merely altered a creditor's remedy, which were not. Cardozo and Stone were both unhappy with what they regarded as an unsatisfactory approach, and Stone wrote Hughes a long memorandum setting forth his views. Cardozo went further. He drafted and circulated a concurring opinion that set forth his view of what the Constitution was all about and how it was to be interpreted. It was not a typical Cardozo opinion because it delves into theory. It was not a typical Cardozo statement of theory either, for it eschewed the usual Cardozo accommodationist approach. At the beginning of the modern debate over the appropriate judicial role in interpreting the Constitution, Cardozo explicitly took sides. But if you look for his opinion in the United States reports, you will not find it, for Cardozo never published it. When Hughes saw the draft, he incorporated a few of its ideas into his own majority opinion, and the collegial Cardozo then did not publish his own opinion. Cardozo's opinion bears quotation at length, for it is the most complete exposition of his constitutional approach, and it is set forth in the context of an actual case. He began by resurrecting the century-old words of Chief Justice Marshall in McCulloch v. Maryland. Marshall's sentences are familiar to us today, but in Cardozo's time, they had been mentioned in a Supreme Court opinion only twice since Marshall wrote them, first in the legal tender cases in 1871, and then in the income tax cases in 1895. We must never forget that it is a constitution, and the words constitution are italicized. We are expounding, Marshall had written, a constitution intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. Marshall had spoken those words in the context of an issue of the extent of congressional power under Article 1, but Cardozo saw them as applying more broadly, in this case to the 14th Amendment's constitutional restrictions on the extent of state power. The lesson that Cardozo drew from the enactment and enforcement of the 14th Amendment on property regulation was not so much that the amendment provided a new tool for judicial review of state regulation. It was that the new tool required that the old tool, the contract clause, be reinterpreted. Cardozo continued, on the basis of that amendment, the 14th Amendment, a vast body of law unknown to the fathers has been developed and expounded by the judges of the nation. The economic and social changes wrought by the Industrial Revolution and by the growth of population have made it necessary for government at this day to do 1,000 things that were beyond the experience or the thought of a century ago. With the growing recognition of this need, courts have awakened to the truth that the contract clause is perverted from its proper meaning when it throttles the capacity of states to exert their governmental power to deal with matters which are basically the concern of government. In Cardozo's history, social and economic changes were reflected in a changing approach to interpretation of the contract clause. Cardozo explained, "The early cases dealt with the problem as one affecting the conflicting rights and interests of individuals and classes. This was the attitude of the courts up to the 14th Amendment, and the tendency to some extent persisted even later. The rights and interests of the state itself were involved, as it seemed, only indirectly and remotely, if they were thought to be involved at all. We know better in these days, with the passing of the frontier and of the unpeopled spaces of the West. With these and other changes," Cardozo continued, "the welfare of the social organism is in any of its parts is bound up more inseparably than ever with the welfare of the whole. A gospel of laissez-faire, of individual initiative, of thrift and industry and sacrifice may be inadequate in that great society we live in to point the way to salvation, at least for economic life. The state, when it acts today by statutes like the one before us, is not furthering the selfish good of individuals or classes as ends of ultimate validity. It is furthering its own good by maintaining the economic structure on which the good of all depends. Such at least is its endeavor, however much it miss the mark. The attainment of that end, so august and impersonal, will not be barred and thwarted by the obstruction of a contract set up along the way." Looking back over the century, he continued, "One perceives a process of evolution too strong to be set back. The decisions brought together by the Chief Justice show with impressive force how the court, in its interpretation of the contract clause, has been feeling its way toward a rational compromise between private rights and public welfare. From the beginning, it was seen that something must be subtracted from the words of the Constitution in all their literal and stark significance. At first, refuge was found in the distinction between right and remedy, with all its bewildering refinements. Gradually, the distinction was perceived to be inadequate. The search was for a broader base, for a division that would separate the lawful and the forbidden by lines more closely in correspondence with the necessities of government. The 14th Amendment was seen to point the way. Contracts were still to be preserved. There was to be no arbitrary destruction of their binding force, nor any arbitrary impairment. There was to be no impairment, even though not arbitrary, except within the limits of fairness, of moderation, and of pressing or emergent need. But a promise exchanged between individuals was not to paralyze the state in its endeavor at times of direful crisis to keep its lifeblood flowing. And then Cardozo demonstrated that he understood the theoretical implications of his approach. Constitutional provisions in a document intended to endure for ages to come, in John Marshall's words, were not to be limited by hewing to the literal words or the original explanations of the meaning of particular constitutional provisions. He explained, "To hold this may be inconsistent with things that men said in 1787 when expounding to compatriots the newly written Constitution. They did not see the changes in the relation between states and nation, or in the play of social forces that lay hidden in the womb of time. It may be inconsistent with things that they believe or took for granted. Their beliefs to be significant must be adjusted to the world they knew. It is not, in my judgment, inconsistent with what they would say today, nor with what today they would believe if they were called upon to interpret, in the light of our whole experience, in Holmes's words, the Constitution that they framed for the needs of an expanding future.